what is the relationship between the Family and Medical Leave Act and the Americans with Disabilities Act? Both acts cover employers, um, require an employer to grant leave for medical reasons. The ADA applies to private companies of 15 or more, while the FMLA covers private employers with 50 or more employees. The extent of the leave is different. The FMLA provides for up to 12 weeks of leave per year for covered conditions. The ADA does not specify a duration. Please note that in the March 2020 Families First Coronavirus Response Act, up to 12 weeks public health emergency leave provisions were made for employers with less than 500 employees. Sorry, with less than 500 employees. So again, sort of helping them to adapt because smaller businesses do struggle when they lose people and things like that nature. In 2012, the Department of Justice regulations removed regarding the removal of access barriers. They really worked hard to try to remove some barriers, and of those specific issues was regarding obesity, right? Someone who is obese simply from overeating is very different than someone who has an underlying physiological cause. And so obesity is trying to address specifically that it is an impairment if there's an underlying condition causing that. Just because someone is overweight is not adequate and is not enough. A substance abuse is like alcoholism. It's separate from related misconduct. It's well established as a qualifying disability. And so substance abuse is fine if you're in recovery, basically. Smoking, most states ban it in the workplace, but related addiction as a disability, hard to know. We haven't seen any cases on it, and you never know what's ahead. So we'll keep a lookout for that as a possibility. But right now, smoking is not a protected class. That's how companies like Waco Corporation can say, we don't want to hire you, or we will not continue to employ you if you are a smoker. They can choose to do that. It's part of the at-will agreement. So it's important that you recognize that. In terms of substance abuse, other drugs, current recreational users are not covered, but former users and prescription abusers are covered. Again, if you're in recovery, that's one thing. If you are currently using it, is an entirely different. Medical marijuana, it's really complex right now. We'll see as we talk in the next chapter about privacy issues, some of the issues around medical marijuana use. But as of 2020, 33 states allow for medical marijuana use, with 11 of those permitting recreational. And I know that it's more since then. I think New Jersey has added in since. Missouri has added medical marijuana, and I'm not sure that's included in the numbers here as of the in this slide. So the ADA uses continuing federal illegality to prohibit ADA eligibility. We're hoping that that will change under the current presidency. Allergies may qualify as a disability, including sensitivity to workplace chemicals. Accommodation may be problematic, but at least we have to try. I had a friend who had problems with exposure to workplace chemicals. She had horrible physiological reactions to them, including migraines, and so she had to have her office space moved to an outbuilding in order for her to be able to do her job. She works at a college. So they put her in a different outbuilding so that she wasn't exposed to those chemicals. Pregnancy or postpartum, pregnancy per se is not covered under the Americans with Disability Act, but it is covered under Pregnancy Discrimination Act. But problem pregnancies may qualify as short-term disabilities. So everything is sort of different. Postpartum depression will qualify, right? But not a problem pregnancy per se. That might be under a different set of rules and laws. Lactation coverage, as you know, is different, and that's about gender discrimination and making sure we've got lactation protection and coverage for individuals. Gender dysphoria, as we've already discussed, is expressly excluded but possibly subject to constitutional attack. And we do know that gender dysphoria may be covered under gender identity issues. So it's not really covered under Americans with Disabilities Act, but it is covered under Title VII with respect to gender identity issues. Service animals, or the animal's presence, must be related to a recognized disability. So Therapy dogs or comfort dogs or emotional support dogs are excluded. So just because you may need to have your dog for comfort, and I appreciate that because my daughter has an emotional support dog, that doesn't mean that they're allowed in the workplace with you. You don't, we don't necessarily get accommodations for that. A service dog is something entirely different. It means that they provide a support like a seeing eye dog, right? Who can actually provide a service for you specifically. Um, they may have to deal with some allergy issues because if there are people in the workplace who may be allergic to the dog, that's a concern, so it would have to be addressed. And we have a nice wide range of management tips. Number one, never assume physical or intellectual limitations of somebody with a disability. Just like we don't want to assume that an older worker can't perform a job, we don't want to assume someone that has a physical or intellectual limitation may not be able to perform a job. We have to evaluate them on their merits, whether or not they can actually do the job, not make assumptions about what we think they can or can't do. We want to review all job descriptions to make sure that the job requirements are actually required to complete the job. So part of your job evaluation or um, um, job analysis, we want to make sure that these are essential and it has to be validated, right? So that we know what is essential and what is not. Ensure that all decision makers understand what constitutes a notice of a request for accommodation and what rights are triggered. So again, when somebody makes a request for an accommodation, what does that process look like in your company? How do you accommodate it? Who has the right to make the determinations? Who has to implement it, et cetera, et cetera? All has to be done. We have to have a process in place for that. We want to be sure to explore all possible reasonable accommodations for an otherwise qualified applicant or employee with a disability. So again, we don't want to say, no, I'm not going to do that. We want to say, okay, what are the range of things that we can do? What's the minimum that you need? And what are some different options so that we can figure out what is the most cost effective option and helps the individual be able to do their job. We want to be able to have frank and open discussions about what people need, what their abilities are. We want to consult with the employee. Ask questions. Don't whisper and hide in the corner. Ask the questions and have an open dialogue about that. Document that dialogue because that's a part of a negotiation. This is how you can determine whether or not the employee has been reasonable in being willing to engage in an interactive, iterative discussion about what is an appropriate accommodation. They need to be proactive. We need to be proactive in making this work. Now, we can't be proactive if we don't know there's a disability. If there's a non-obvious disability, we need to know that, but we should be proactive in coming up with solutions once we're made aware. And we need to be willing to negotiate and make a fair and reasonable counter proposal. It's like, okay, we could try doing this. Is there something that we could do that might be a little cheaper? That might be we could do it differently, and this might make it easier for us to accommodate you in some manners. We want to be clear on the rules for when medical exams can be required of a disabled person. And again, we're not going to remove them from consideration if they don't pass aspects of that medical exam. We have to know what the purpose of that medical exam is, and we're not going to require just the disabled person to do the medical exam that we can expect. That'd be something that we need to consistently ask of everybody. We want to review all application materials to ensure that there are no inappropriate questions regarding irrelevant abilities, right? So if something is irrelevant and it doesn't matter, we shouldn't be asking that question. All decision makers should understand that they can violate the ADA even if the employee has no disability, but if they were treated as if they have one. So again, if you're making an assumption that someone has a disability, that is still covered under the ADA. All disabilities need not be accommodated. Again, if there's an undue hardship, this is a real problem for the organization. If it's just untenable, and it may not be reasonable to be able to hire somebody with a particular disability with a particular circumstance. Documentation or medical exam prior to an employee's return to work, if he or she is on leave, can be requested to make sure that they're cleared for work. We want to make sure that we're posting the information about GINA, the Genetic Information Non-Discrimination Act, particularly if we are required to adhere to it. And all equal employment opportunity statements and manuals should be included, amended to include references to genetic discrimination and the ADA.